Okay, so what do we have today? I'd like to take a look at the voiceover lawsuit first. The plaintiffs are Paul Lehrman and Linnea Sage. So this might be him. And he's certainly a popular voice actor. Yeah, that's him, all right. And let's look up Linnea Sage. So there's Linnea Sage. Actually, she does kind of look familiar. The defendant is LOVO Inc., L-O-V-O in capital letters. They state as follows. This is a class action lawsuit brought on behalf of plaintiffs and those similarly situated whose voices or identities were stolen and used by LOVO, the defendant, to create millions of voiceover productions without permission or proper compensation in violation of numerous states' right of privacy laws and the Federal Lanham Act, which is trademark. LOVO is a technology company with proprietary software driven by artificial intelligence that allows LOVO clients to create and edit voiceover narrations adapted from real actors. To be clear, the product that customers purchase from LOVO is stolen property. They are voices stolen by LOVO and marketed by LOVO under false pretenses. LOVO represents that it has the legal right to market these voices, but it does not. The voiceover industry is estimated to generate more than $2 billion annually in the US and more than $4 billion annually worldwide. Voiceovers, commonly known as narrations, are integral to various industries spanning entertainment, advertising, marketing, education, and other corporate sectors, and law explainer videos. They serve as indispensable tools across a wide variety of mediums, including film and television, commercials, animation, audiobooks, e-learning, corporate presentations, marketing presentations, educational videos, interactive voice response systems, podcasting, video games, documentaries, virtual assistants, public announcements, dubbing, radio imaging, not dubstepping, audio dramas, museum exhibits, phone systems, language learning, medical narration, corporate training modules, websites, sales pitches, and digital content. They are even used in venture capital funding pitches. Traditionally, actors are hired to read scripts, which may be recorded in outside studios or with the actor's own equipment. The recordings are then edited, changes or re-recordings are produced, and a final recording is laid into the show or presentation. The actors are paid a negotiated amount for the use of their voices. This is the bargained for consideration when you're thinking of contract law. So think about what they bargained for, and then was LOVO using the voice beyond what was bargained for, what was contracted? The actors are paid a negotiated amount for the use of their voices and typically for the time spent recording the audio requested. The negotiated amount is a function of the actor's name, brand value, where and in what medium the voiceover will be used, and for how long it will be used. Payments typically include upfront fees, royalties, residuals, or some combination of these payments. And there are other potential fees required under the Screen Actors Guild, the American Federation of Television and Radio Artists contracts, so SAG-AFTRA contracts. Actors, like plaintiffs, get paid anywhere from $150 for a short recording for a local television tag, to $2,000 for a one-time sales presentation, to $6,000 minimum for a 13-week run of a TV commercial, or more, depending on the project. Established actors can typically make much more via residuals and through daily fees which can exceed $1,000 per day and can involve several weeks of work. Failure to pay the actor a negotiated and agreed upon price for their professional services, and often the recognizability of their voice, is a violation of multiple statutes and common law. Defendant LOVO, by its own admission, is attempting to disrupt and revolutionize this traditional model. LOVO sells a text-to-speech subscription service that allows its clients, typically companies, to generate voiceover narrations at a fraction of the cost of the traditional model. LOVO does this by allowing subscribing customers to upload a script into its AI-driven software known as Generator or Jenny, and generate a professional quality voiceover based on certain criteria. For example, LOVO customers can choose between and designate their preference for male or female voices, regional accents, and older or younger sounding voices. As of January 2023, LOVO has created over 7 million voiceovers. In a podcast, LOVO's chief executive officer and co-founder Tom Lee explained how LOVO's synthetic speech platform works. Quote, Imagine you have a real human voice and we take that and clone that and make it available as an option for you to turn any text that you have into that voice. So you make that voice say anything you want, even if that person has never actually said that before in their life. In that same podcast, Mr. Lee then stated that LOVO only needs a person to read 50 sentences. We can capture the tone, the character, the style, the phonemes, and if you have an accent, we can capture that as well. LOVO also promotes its service using barely disguised images and names of celebrities and states on its website, clone any voice. Only deep in its website does LOVO tell customers, mind you, you cannot use this cloned voice for imitation of celebrities, so only use this tool for personal entertainment purposes. LOVO purports to compensate voice actors. That may be true in some cases, but plaintiffs and other members of the class have received no revenue from the continued unauthorized use of their voices by LOVO and LOVO clients. The benefit to the business subscriber of using LOVO's service is financial. They do not have to pay the actor the studio session, any residuals, royalties, or fees beyond the monthly subscription paid to LOVO. Implicit in LOVO's offerings to its customers is that each voiceover actor has agreed to LOVO's terms and conditions for customers to be able to access that actor's voice. But for plaintiffs and other members of the class who have not agreed to LOVO's terms, the continued unauthorized use of plaintiffs' voices is theft of service and misappropriation. Plaintiffs and many of its members of the class are members of SAG-AFTRA, the Screenwriters Guild, the union. On its website, LOVO represents to potential clients that it has agreements with actors allowing LOVO to utilize their voices, but it is emphatically not true with respect to plaintiffs. LOVO had no permission to use plaintiffs' voices for training its AI generator to promote the LOVO service or to market voices based on plaintiffs' voices, and LOVO have never compensated plaintiffs for the unauthorized use of plaintiffs' voices. So then I think we're going to get into some very specific facts here, so the actual story here. So what happened to Plaintiff Lehrman? In May 2020, Mr. Lehrman was contacted via the Fiverr website to provide voiceover narrative services. Fiverr.com is an online marketplace that connects freelancers with clients looking for digital and creative services. If you haven't heard of it, it's 5rr.com, so Fiverr plus an extra r.com. Using the Fiverr platform, Mr. Lehrman communicated about the inquiry with someone who can now only be identified by their username. The account has since been deleted. As Mr. Lehrman was preparing to upload the voice files requested by the hiring company, he asked the user, in addition, can you please explain how the voiceovers will be used? The user answered, we are researching speech synthesis with different accents and voices. Your voiceover will be used for academic research purposes only. Mr. Lehrman wrote back, great, still working through the scripts. Please guarantee that these scripts will not be used for anything other than your specific research project. My curiosity is getting the best of me. What is the goal of the research project? The hiring party writes back, the scripts will not be used for anything else. I can't tell you the goal. It's confidential work in process. Sorry, haha. Mr. Lehrman responded, that's okay. My voice will be repurposed and used in a different order. The user responded, the script and your finished file will be used for research only. Mr. Lehrman delivered the requested voice files and was paid $1,200. In 2020, no one knew what speech synthesis was. Mr. Lehrman's voice was being used for academic research purposes only. That was a reasonable explanation. Today we might know what AI is and to be careful of this, but back then this wasn't a thing. At no time did the user accurately represent that Mr. Lehrman's voice would be used for anything other than research purposes. Several years later, Mr. Lehrman learned that that user was an employee of LOVO and the company that reached out to and hired Mr. Lehrman was LOVO. Then, on March 28, 2022, Mr. Lehrman was approached by Fiverr and asked if he would like to add an AI software option to his Fiverr profile. Mr. Lehrman was told by the Fiverr executive that the AI software option would integrate software to his profile and allow customers to hear what Mr. Lehrman's voice could sound like if he were to read a script. Mr. Lehrman declined. Mr. Lehrman demonstrated to Fiverr that a user could easily produce commercial audio without consent or compensation, as well as create violent, pornographic, or unauthorized audio material without consent from the voice actor. Then on April 6, 2020, plaintiffs learned that InTech, a YouTube channel now called Military News with more than 336,000 subscribers, had created and was promoting videos about Russian military equipment that used plaintiffs, Mr. Lehrman's AI-generated voice. To be clear, Mr. Lehrman never recorded the YouTube videos. They were generated by a then unidentified AI software without Mr. Lehrman's participation or approval. Concerned about the unauthorized replication of his voice on the YouTube channel, Mr. Lehrman contacted the Fiverr executive, seeking to identify the AI software used. The executive committed to consulting with the legal team. The Fiverr executive identified this company as LOVO, a name Mr. Lehrman was unfamiliar with at the time. Intech used LOVO's software to misappropriate and utilize Mr. Lehrman's voice without his permission or compensation. Then, on June 13th, 2023, Mr. Lehrman heard his voice being used on a podcast episode of Deadline Strike Talk. Ironically, the episode was about the dangers of AI technologies. The Deadline Strike Talk podcast was created by LOVO Software. Mr. Lehrman never gave permission to LOVO or to the Deadline Strike Talk podcast to use his voice, nor was he ever compensated for that unauthorized use. It was not until August 30th, 2023, that Mr. Lehrman learned that the Fiverr client that requested his voiceover recording was a LOVO employee, and that admission was only made by LOVO's counsel, after plaintiff's counsel sent a cease and desist letter. Well, that's pretty damning. Isn't this some kind of unfair competition? The people who are willing to break the law get to develop these AI models faster than the people who didn't break the law? So those of us who didn't break the law are now, in a business sense, we're a step behind. And so isn't that some kind of getting something that you're not entitled to by a lie, which is fraud? That's fraud. That's not even little fraud. That's fraud. So I'm imagining we're going to see a civil fraud claim in here. Let's take a look at the other plaintiff first. On October 29th, 2019, Plaintiff Sage was offered a job on the Fiverr website to produce test scripts for radio ads. Before accepting, she asked what the voice recording would be used for. She received a message from an anonymous company saying these are test scripts for radio ads. They will not be disclosed externally. They will only be consumed internally, and they will not require rights of any sort. She accepted the job and was paid $400. It turns out that user was a LOVO co-founder, Tom Lee. Some years later, Ms. Sage discovered that LOVO had been using, manipulating, and editing her voice in promotional materials for LOVO for many years, including but not limited to a 5-minute investor presentation at the Berkeley Skydeck Demo Day Spring 2020 event, which was also posted to YouTube. This event helped raise money for LOVO. This example of her actual voice can be accessed. Let's see if we can access it.
Does your child have difficulty reading? Is mathematics a thorn in their side? Our certified teachers are ready to help your son or daughter conquer their fears of reading, writing, arithmetic, and more.
Yeah, so that's remarkable. The woman that was the second example there is the example that she's referring to. That's our plaintiff, Ms. Sage. And that was at a fundraising event for LOVO. So they raised millions of dollars in venture capital using Ms. Sage's voice in an unauthorized way without compensating her or getting the right license. Ms. Sage never authorized LOVO to use her voice for public use, nor was she ever compensated for its use or made aware of its use, the differing use. So there's further allegations. Mr. Lehrman began investigating whether his voice had been used for LOVO or anyone else. LOVO used Mr. Lehrman's voice to promote its Jenny service without Mr. Lehrman's permission. This use of Mr. Lehrman's voice as Kyle Snow can be heard at this link. So let's grab this link.
Our greatest weakness lies in giving up.
Okay. So that was Mr. Lehrman's voice as Kyle Snow, generated by LOVO. The Kyle Snow voice was unquestionably Mr. Lehrman's voice. To be clear, LOVO never said Kyle Snow was Mr. Lehrman. Instead, LOVO did something even more insidious. It created a fake character, Kyle Snow, and animated it with Mr. Lehrman's voice. LOVO stole Mr. Lehrman's voice, his protected property, and marketed it and sold it as if it were its own. Lehrman was never compensated for that use. He also found that LOVO had published an article on its website entitled 5 Best Practices for Perfect Audio Advertising, promoting LOVO's services that featured Mr. Lehrman's voice and attributed that voice to Kyle. LOVO also promoted Mr. Lehrman's voice as Kyle Snow and said it was one of the 5 best male voices for text-to-speech. With his upbeat tone and slightly faster speed, Kyle Snow has the perfect voice for conveying enthusiasm and youthfulness. This makes him an ideal male voice generator text-to-speech option for all kinds of content, from audiobooks and narrations to commercials and social media. So they made his voice like of sort of front face of their company, and they didn't have permission to use it. They just expected he would never figure it out, which is often the short-sightedness of some of these tech startups. Mr. Lehrman learned that from 2021 to 2023, his voice was the default voice for the software. Mr. Lehrman never authorized LOVO to use or manipulate his voice for LOVO's service or any other use, nor did he authorize LOVO to connect his voice to the stage name Kyle Snow. Mr. Lehrman was never made aware of nor compensated for the unauthorized usage of his voice. LOVO's scheme not only unlawfully appropriated, used, sold, and marketed Mr. Lehrman's voice, but interfered with his ability to earn a living. LOVO knew that its scheme was in violation of the agreement with SAG-AFTRA and threatened Mr. Lehrman's relationship with SAG-AFTRA and those producers. Plaintiff Sage subsequently learned her voice was marketed by LOVO as part of its subscription business under the name Sally Coleman. LOVO never explicitly stated that Sally Coleman was Ms. Sage. LOVO did something more insidious. It created a fake character, etc. Similar claims to the previous allegations from Mr. Lehrman. Meanwhile, LOVO tries to play it off that Callie Snow and Kyle Snow and Sally Coleman are not popular and sales are negligible, even though it's the 5 best voices for text-to-speech. LOVO wrote a glowing review of Ms. Sage's voice on Fiverr. Stellar is an understatement. We would recommend her to anyone. And of course, they're using her voice without her permission. And there's some of the receipts. These are test scripts for radio ads. They will not be disclosed. There's Tom. Tom L. Defendants' counsel informed plaintiffs that their voices will be removed from the LOVO service. On August 30th, LOVO's attorneys stated that their voices were removed. However, their voices were still available to new customers through the end of September, and their voices are still available to any LOVO customer who previously downloaded the voices. And even though plaintiffs directed defendant to preserve all documents related to this matter, LOVO deleted the messages that were part of the Fiverr correspondence between Ms. Sage and the LOVO representative. Ironically, LOVO itself recognizes the threat of improper usage of AI voices. Tom Lee wrote in 2019 for Medium, "Some people are alarmed by the possibility of their voices being used unbeknownst to them or in malicious, illegal ways. Others are concerned that they are going to take away the jobs. While they are right to be concerned, it shouldn't be a divisive confrontation. Just like how we must be wary of our images, names, affiliations, and identities, we must ensure that our laws and ethics develop in step with the technology to create a safe environment." The founders of LOVO created another company, VoiceVerse, which sold voice NFTs. The founders stated on the pitch website, "A person's voice is uniquely linked to their identity. Once you hear that person's voice, it immediately reminds you of them and memories you had with them. Voice is personal. Voice brings out emotion. Voice is unique. Voice is a powerful aspect of one's identity." Defendants' improper use of celebrity names and likenesses of other voices. Defendants also borrow voices from well-known celebrities, including Barack Obama, crudely represented as Barack Yo Mama. Conan O'Brien is Cocoon O'Brien. Elton John is Elton John Cena. Defendant boasts that its Jenny tool allows users to clone any voice and create high-quality custom voice content, and illustrates that capability with barely disguised names and images above. Here's Elton John, for example.
I'd reached the point where I didn't know how to speak to someone unless I had a nose full of cocaine and a stomach full of liquor. And increasingly, even that wasn't enough. You are whatever a moon has always meant and whatever a sun will always sing, counting the hours until we're together again.
So this is a class of all persons whose voices were used by LOVO without permission, etc. You might be in the class. This is not legal advice. If you think you might be in the class, you probably want to contact your own attorney. Especially if you are Elton John or some other large celebrity, A-list celebrity whose voice was used, you need to be contacting your attorney and joining in this lawsuit or filing one of your own. If this is true, this is amazingly stupid on the part of this company. They could have had these actors give their voices for the appropriate sum of money, but no, they just took them instead. Again, assuming this is true. So, violation of New York civil rights laws. Well, great. Okay, are we on diversity jurisdiction? Because that's a state claim, and that's your first claim, so we better be on diversity jurisdiction. Deceptive acts and practices in violation of New York law. False advertising in violation of the New York False Advertising Act. Unfair competition and false affiliation. Now here's our federal claim under the Lanham Act, under trademark. False advertising, again, a different claim. Unjust enrichment. You hired us for one thing and then used it for another, beyond the purpose, beyond the benefit of the bargain, beyond the terms of the contract. So you are unjust enriching yourself. Now, it should just be contract violation, but okay, you include unjust enrichment. Tortious interference, as in they have an agreement and now their voice has been used outside of that agreement with SAG-AFTRA. And as I predicted, fraud. So fraud must be pled with particularity. So let's see if this was particular enough. LOVO committed fraud by materially misrepresenting to plaintiffs that the ultimate use cases of their voice recordings would be not new voices. LOVO omitted to tell plaintiffs that they would use the voices for new voice options for the service. Defendant knew what the use would be of the voice recordings and did not tell them. Plaintiffs reasonably relied on these misrepresentations, and they confirmed that the voice recordings would only be used for academic research purposes and not public purposes. Plaintiffs were damaged by the misrepresentations. They have not been fully compensated for their voices, and their voices have been used without permission. They would not have given permission had they known the truth. So, what are we asking for? We're asking for class action status, meaning anyone who's been wronged by this company under these facts, these similar facts to this, can join the class. And it might even be that the opposite is true. Everyone who's been wronged might all automatically be in the class, and the judge will have to send, or the judge will have the class representative send everybody notices, like you've gotten in the past if you've been part of a class action lawsuit, like the PlayStation 3 one, for example. The PlayStation 3, what was it, Linux boot option or something they took away? We all got a little bit of a check. It was like $3 or something. So class action status, compensation exceeding $5 million to be determined by proof. Let's see, appropriate relief, actual statutory damages, punitive damages, civil penalties, restitution, disgorgement of profits, enjoining the defendant from continuing to engage in wrongful acts and practices, the costs of prosecuting this action, including expert witness fees, which you don't normally get in copyright, so that's why this is not brought as a copyright lawsuit, possibly. Awarding reasonable attorney's fees, prejudgment and post-judgment interest, and all other relief the court may deem just and proper. That's Pollock Cohen, Steve Cohen, and Anna Minkova. Attorneys for the proposed class. Nice lawsuit there. Sorry about the facts, but it's a common sentiment. So yeah, what the hell? There's so many ways to do these things properly, and then I think what's happening is these tech companies are so used to getting away with disruption that they just go and disrupt and then decide we're going to figure out how to pay for it later. And oftentimes the payment later ends up being less than what they made. So as long as they weren't dumb enough to go blow all the money and they had some left over for the legal risk, then they get to continue to be bad actors, but not pay a price that causes them to correct their bad behavior. Instead, it causes them to simply make it part of a economic calculation on a ledger or spreadsheet. It's just another item added to the cost of doing business. I've said this before, I'll say it again. If you have a law that punishes people for speeding on the highway by giving them a $50 fine, I'll use a very specific number for a reason, by giving them a specific small fine, $50, people who can afford $50 or people who make more than $50 by speeding, it's just an economic calculation for them. It's not a law. It's not a punishment. It is legal for them to speed. It just costs them $50. So if you're rich enough, or if it works into your economic calculation, then you're going to do that because that's easier. But meanwhile, someone who can't afford to pay the $50 might be at a real life and business disadvantage that you get to make a profit off of breaking the law, while someone who can't break the law, can't afford to break the law, doesn't. So that's what I'm talking about. It's very unfair that LOVO has a head start on copying celebrity voices because they did it illegally, and their company will be ahead of other companies who did it legally. Think of Tesla, for example, everyone's favorite car company to hate on because of Elon Musk. I actually don't have a problem with Tesla. I have a problem with Elon Musk. But Elon Musk over the years has said a lot of things, like full self-drive will be ready this year, 10 years ago or 8 years ago or whatever it was. Obviously, it is still not ready. It is still not full self-drive. It is simply a advanced cruise control. My car has advanced cruise control. I like it, but I would never trust it to drive me from place to place without intervention. It's supposed to be a collaborative drive. The two drivers, the car driver and the car and the driver work together to make the thing safer. Not the driver gets to fall asleep while the car operates, on the best it can do. That's not the same thing. Did Tesla get an economic business advantage by promising customers, we have level 3 full self-driving ahead of everybody else, when they didn't really even have level 2 full self-driving ahead of everybody else? Yes, they got a business advantage, and they are probably going to be charged. Somebody's going to be charged with some kind of something eventually. I hope. There certainly should be an investigation. I think that's what we heard last week, was there's an investigation into whether Tesla misrepresented full self-drive. People have been paying $15,000 for this software that supposedly will be ready any day now and is still not even close to ready, and probably won't be ready for 5 or 10 years unless there's some major breakthrough that we don't know about yet. So did they get an economic business advantage? Do they have a head start over others that they got because of their lies, which is fraud? Getting something you are not entitled to by lying is fraud. So that's what this is. This is fraud to do this to these voice actors. It's fraud to sell full self-driving software that's not actually full self-driving. It's fraud to sell somebody something that doesn't work just so you can get the money, and then later on try to catch up with the pyramid scheme of it and, pay them off by fixing it in time before they get mad enough to sue. You're hoping from a business perspective that there won't be enough people who make claims that it ultimately works out profitable to have done the immoral, unethical, illegal thing. So that's what that's about. Let me know what you think in the comments below.